without any confirmation that that was a patient. Only 2 of those 7 dispensaries rejected the person who did not have confirmation they were a patient. So, is there a knucklehead factor out there? I'm pretty sure there is. So, we're going to get the knuckleheads out very quickly, and then the legitimate business people are going to come in. So, I want to be clear, we're going to have to staff up, and we're going to have to charge fees.
The question is the adoption of Floor Amendment 163. All those in favor say aye.
Aye.
Opposed, no. Floor amendment is adopted. Mr. McGowan, please read Floor Amendment 154.
Amendment 154 to House Bill 1284 by Senator Stedman, amendment re-engross bill
Senator
page 20.
Stedman.
Thank you, Madam Chair. I move Amendment L154. And colleagues, I have a series of floor amendments that do some housekeeping cleanup to the bill. And if you'll bear with me, Amendment 154 corrects or clarifies language in here about eligibility for licenses. There's a reference to a person cannot have a license if they haven't paid their student loans. And there is some concern that the interpretation of that will mean someone with an outstanding student loan balance is ineligible for a license. This amendment rewords that to make it clear that the disqualification for licensure is if you're in default on a student loan, not merely having an outstanding balance that you're still paying down. Ask for your support on 154.
Senator Romer.
Thank you. I support L154.
Question is the adoption of Floor Amendment 154. Those in favor say aye.
Aye.
Opposed, no. 154 is adopted. Mr. McGowan, please read Floor Amendment 155.
Amendment 155 to House Bill 1284 by Senator Stedman, and re-engross bill page 51, line 5 strike.
Senator Stedman.
Thank you, Madam Chair. I move Amendment L155. Colleagues, what this does is it changes the current provisions in the bill that say that July 1, 2015, this act will go through sunrise. And it instead says that it will go through sunset. Because if you're familiar with our sunrise-sunset laws, they are 2 different processes. Sunrise is an application to regulate a previously unregulated occupation, profession, or industry. And sunset is a look back at how an existing regulatory scheme has affected a regulated occupation, profession, or industry. And so all this does doesn't really change any of the dates or any of the things that are going to happen, but it codifies this requirement in the correct section of statute rather than the awkward, misplaced section that the House sent it over to us with it, and calls it by its proper name, which is a sunset review. Ask for your support.
Senator Romer.
Thank you. I support L155.
Question is the adoption of Floor Amendment 151. All in favor say aye.
155.
No, 155, excuse me. Those in favor say aye.
Aye.
Opposed, no. The floor amendment passes. Mr. McGowan, please read Floor Amendment 156.
Amendment 156 to House Bill 1284 by Senator Stedman, amendment
Senator
re-engross bill.
Stedman.
Thank you, Madam Chair. I move Amendment L156. And all this does is tighten up some citation. What it is on denials of application, it says that the state licensing authority may deny if the premises do not meet the requirements of certain sections that are cross-referenced. And when you go to that cross-reference, it's actually the definition of good cause, which is broken into 3 paragraphs, only one of which have anything to do with premises. And so I'm just trying to tighten it down and point the one that says the premises have been operated in a manner that adversely affects public health, welfare, or safety of the immediate neighborhood. Just trying to tighten it down so that when you read this bill and you look at the cross-references, you're sent to the right place.
Senator Romer.
Thank you. I support L156.
Question is the adoption of Floor Amendment 156. All those in favor say aye.
Aye.
Opposed, no. The floor amendment is adopted. Mr. McGowan, please read Floor Amendment 159.
Amendment 159 to House Bill 1284 by Senator Stedman, amendment
Senator Stedman.
Thank you, Madam Chair. I move L159. This, colleagues, goes to page 28 of the bill, where for some reason the bill starts talking about operators of medical marijuana centers. And it's actually the requirement that the operator shall be a resident of Colorado. And if you read the rest of this section of law, it breaks out owners, officers, managers, employees, and all the previous paragraphs. When we talk about the various people involved in with licenses, it's always referencing owners, officers, managers, and employees. And in this one paragraph, it says operators. There is no definition anywhere in the statutes for what an operator is. And so I think this residency requirement is intended to apply to officers, owners, officers, managers, and employees, and I'm just substituting those words.
In just one place.
No, yeah, right there, because it's the only place you use that term.
Senator Romer.
Thank you. I support L 159.
Question is the adoption of floor amendment 159. Those in favor say aye.
Aye.
Opposed, no. Floor amendment 159 is adopted. Mr. McGowan, please read floor amendment 160.
Amendment 160, House Bill 1284 by Senator Stedman, amendment read Gross Bill, page
Senator
25.
Stedman.
Thank you, Madam Chair. I move Amendment L160, and this is still cleanup on page 25, where we're talking about restrictions around proximities to schools, universities, college campuses, seminaries, or residential child care facilities. There's a reference at the bottom to the local government varying from these things, and it says it can vary it for schools or campuses, but it doesn't talk about a variance for a facility or a seminary, or maybe a seminary is a school, maybe it's a campus, I'm not sure, but the RCCF is certainly left out, and so it adds facilities. On page 35, and this is actually quite important, there's a provision here about centers selling infused products, medical marijuana infused products, and it says that they can sell edible infused products, when actually many of the infused products are not edible. They are topicals. They are things that can be applied other ways, and so it strikes the word edible to allow the entire spectrum of infused products. That's the amendment, and I would ask for its adoption.
The question is the adoption of Senator Foster.
Thank you, Madam Chair. Senator Stedman, I just want to make sure that with regard to placing these operations that local governments can use their own discretion. Is that what you're saying?
Senator Stedman.
Thank you, Madam Chair, and yes, Senator Foster, that's exactly correct. On the ability of the locals to vary these restrictions around proximities to schools or campuses, I want to make sure that, because there's a reference earlier to the distance from a residential child care facility, that is also something a local government would have the local option to vary.
Thank you, and I would support this amendment.
Question is the adoption of floor amendment 160. All those in favor say aye.
Aye.
Opposed, no. 160 is adopted. Mr. McGowan, please read floor amendment 158.
Amendment 158, House Bill 1284 by Senator Stedman, amendment read Gross
Senator
Bill.
Stedman.
Thank you, Madam Chair. I move Amendment L158. And what this does is it strikes all references to use tax. As I was reading the Local Government and Energy Committee report, I saw that there were a couple places in the committee report where you struck references to use tax. It had said sales and use tax, which is generally how we refer to that in statute. But when you think about it, use tax is rather inapplicable in this instance, because use tax involves not purchasing something here but bringing it into this state to use it here. And with medical marijuana, there is no interstate commerce. We're not allowing people to bring this in over state lines. And so this strikes all the remaining references to use tax, so that when we talk about the taxation issues, we're being really clear that what's being paid is a sales tax.
Senator Romer.
Thank you. And just, for the record, I want to make sure there's nothing here to impose restriction on sales tax at this point in time. And members for the body, you know that we have an odd circumstance here where this is currently the only product which we're calling in our Constitution medicine, which we are taxing. And the decision on that is that it's being treated more as a supplement rather than a pure FDA medicine. So I'm going to support this amendment. I just want to draw attention to the body that at some point, and when this actually turns into evidence-based medicine with FDA support, of course, we ought to remove all taxation from this product at some point in the future.
Senator Stedman.
Thank you, Madam Chair. And Senator Romer, I concur with you that the taxation issues warrant further debate, and that's not necessarily what we're settling here. This is merely being consistent with what was done in the committee report as far as the issue of sales and use tax, and clarifying that we're just talking sales tax. I understand from conversations I've had with the bill drafter that this is something the Department of Revenue brought up, and that's why in Local Government Committee some of the references to use tax were stricken, and Amendment 158 strikes the remaining ones.